Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. This Legal Bites we're calling Mind the Gap. And currently it's Friday, July 26th, 2024. And by Mind the Gap, what I'm referring to is in some cases with some MLSs in the state of Colorado. And remember, I think we've got 13 different MLSs in the state. So some of those MLSs for, I think, primarily back-end programming reasons and ability to get their vendors to pick up, to convert the MLS practice changes on a exactly the 15th, are implementing their practice changes earlier. I've heard dates anywhere from August 1st all the way through, right up until the 15th. And some MLSs are actually implementing the changes on the 15th. And in that case, you don't need this video. So if you're a participant in the MLS that is implementing their practice changes and removing the offer of compensation, most specifically on August 15th or up to August 17th, which is the last day they have to make those changes if they opted into the settlement agreement. If you're an MLS in one of those, if you're an MLS participant in one of those MLSs where it's August 15th practice changes or later, then you don't have to watch this video. Ignore it. I'll wait for you to leave. Okay, bye. Now they're gone. This video is for anybody who is implementing their practice changes before August 15th. And like I say, I've heard as early as I think August 1st for some of them. So the reason it's called Mind the Gap is of course a play. I've got a moderately creative, wise friend that suggested that title. And what I'm trying to address here is an MLS, let's just use August 1st as an example. The implementation of the practice changes, the removal of the offer of compensation is coming on August 1st, 2024, or any time before the 15th. The point of this is that the gap that I'm referring to is the gap between the date of implementation for your MLS and August 15th, because August 15th is when the commission approved forms become mandatory. But the thing with being mandatory, when the commission promulgates their forms, they're mandatory to be used at, in this case, beginning 12:01 a.m. on August 15th. Those forms, the new commission approved forms, have to be implemented. The other side of that, when they say mandatory for use, is they can't be used by licensees in Colorado before 12:01 a.m. on August 15th. So the forms are, while you can see them in the red line and draft versions on the website, they've got watermarks and they can't be used until August 15th. And so this gap is going to be, if you're implementing practice changes or turning off the offer of compensation on August 1st, you've got, in that case, a 15-day gap in forms that you have available for your use. And so I need to talk about that in the situation where MLS participants are dealing with an earlier implementation of the practice changes and the removal of the offer of compensation. So that's the gap that we're talking about, is whatever period of time is between your MLS practice changes and the availability of the commission approved forms on the 15th of August. So we know there's essentially four broad categories of documents that we're talking about: the exclusive right to buy, exclusive right to sell, contract to buy and sell, and the broker disclosure to buyer that are being modified and have implications related to the offer of compensation. If you are a broker in one of those MLSs, let's say August 1st, you are going to still be using, because that's all you're going to have available to you, the current versions of those four documents. You can't use the new versions until August 15th. So it's important to do a few things as you're implementing the existing forms in anticipation of the changes. And so exclusive right to sell, as I mentioned in my webinar the other day, I don't think there's a lot of modifications that you're going to need to make to an exclusive right to sell entered into before August 15th and on the new form. Those changes are going to be pretty consistent unless your seller wants to reduce compensation. The ones I'm more concerned about are exclusive right to buy, if you're entering into one of those on a current form. And at this point, I would tell you, no matter what MLS you're on, you probably ought to just start acting like the only available options for a buyer are buyer will pay, period, or buyer will pay, seller listing brokerage firm may pay. And because if you're checking that box that says buyer is not obligated to pay, then you're setting yourself up to have to need to do an amendment to that agreement after the 15th, because remember, that option is being removed from the new contracts. So I wouldn't even be at this point using that option, buyer is not obligated to pay. I'd negotiate with your buyer your success fee. And the other thing I would be doing immediately, and not even though you still could do it now, I would not be using any ranges for your success fee. It needs to be a hard fixed number. And because again, once the practice changes go into place, then that's going to be the requirement of your MLS, that you have a fixed number, a percentage or a dollar amount that your buyer is obligated to pay you. And so please, if you're in that gap period and your MLS practice changes are already in place, beginning, let's say in my example, August 1st, and you're using the current forms, not the new forms because they're not available, make sure that you're using them in a manner that is consistent with the new red lines. So having checking the box, buyer is obligated to pay, or the buyer is obligated to pay, seller or listing broker's firm may pay. But don't use the buyer is not obligated to pay in that scenario. On the existing form, and use the fixed number for your success fee. So that's how you're going to have to treat it in that gap period for these new forms on the exclusive right to buy. The other form that you're not going to have available is you're going to default to a transaction broker. You're not going to have the brokerage disclosure to buyer that has the compensation agreement at the bottom. That compensation agreement, again, is not being activated until August 15th. So you're going to really be better off in that case just using the exclusive right to buy with your buyers and not using the broker disclosure to buyer only, because then you won't have a compensation agreement with your buyer to compensate you, which makes it difficult as well in that situation. So and then let me just tie that into the contract to buy and sell. So if you're writing an offer in a contract after August 1st, because your practice changes are in place, you are going to need to address in the additional provisions pretty much the same language that is currently in that paragraph 29 on the red line of the new form, the new contract to buy and sell that's coming from the Real Estate Commission beginning August 15th. What does that mean? It means that in the additional provisions of any contracts you are writing after your MLS practice changes, again, in my example, assuming they happen on August 1st or before August 15th, you're going to need to have an additional provision that says seller is going to pay you through the contract, and you could probably copy and paste or use essentially the language that's going to be coming to you on August 15th in paragraph 29, so 29.1 of the red lines. Use that language in the additional provisions if your seller has authorized you to negotiate your success fee with the seller or listing broker. But you're going to have that, because otherwise you don't have the offer of compensation anymore after August 1st. So I know this is very complicated, and I'm sorry, there's just no way to make it simple. Unfortunately, it's complicated stuff in this transition period. So make sure you're addressing your compensation in the contract if you expect the seller or the listing brokerage firm to pay you. The good news now is that you do have currently available to you, and you can use that right now because it's already been released and it's approved for use, the Colorado Bar Association's brokerage firm compensation agreement. So if you have that, then you're also going to, and you expect the listing brokerage firm to pay you. Remember, once that offer of compensation is gone, there's no offer of compensation, whether that's August 1st or 6th or 10th or 12th, it's going away in your MLS. So that means you're going to need something from the listing brokerage firm if you expect the listing brokerage firm to pay you, and that's going to be that brokerage firm compensation agreement. So if you're on one of those MLSs where August 1st offer of compensation is gone and you want the listing brokerage firm to pay you, you need to be utilizing the Bar Association's brokerage firm compensation agreement beginning on that date. As soon as the offer of compensation is turned off, the practice changes are implemented early in this case on your individual MLS. You need to be able to secure and memorialize your compensation. That's going to be the form to use. So I hope this makes sense. If you don't, as you guys know, the Car Legal Hotline is available. You're killing us this week. The last couple of weeks, just unbelievable call volume, mostly related to all of these questions. And I get it, guys. It's complicated stuff, but I'm hoping that this addresses the questions that we've been getting. And I know the concerns that I've had related to what I'm describing as that gap period from the date of your implementation on your individual MLS up until the 15th, when you will get all of the commission approved forms that are going to address those changes. So again, in some cases, it's been done earlier than the 15th for various reasons. That's how you're going to have to live with it. I hope that helps on those agreements and how to use them. But you can't use the new forms, as I mentioned, until 12:01 a.m. on August 15th. So you're going to have to kind of make do. Hope that helps. Call the hotline if you got questions, and be well, guys. Everybody is going to get through this. I promise we'll make it through. Take it easy, and we'll see you again on another edition of Legal Bites. Thanks so much.